seated. We have 4 cases on our docket for this afternoon, and we will hear the cases in the order in which they appear. We will take a short break after the first case, and you're welcome to join us in the Commons for coffee. We've got coffee set up over there. So, counsel prepared on the first case, State of Florida versus Eric Young. You may proceed.
Christine Gard on behalf of the State of Florida. I'd like to reserve 5 minutes for rebuttal.
Let me just briefly interrupt you to talk to all counsel. I assume everybody has been instructed on the clock and how it works. I'll try not to interrupt in the middle of your argument, but if I see you're running into your rebuttal time, if you're the appellant, I'll try to remind you. Go ahead, counsel.
Thank you. We're here today because the trial court suppressed the evidence, which was a video clip containing child pornography that was found on the church's computer in the pastor's office. The trial court essentially reached an incorrect conclusion of the law as it applied it to the facts. The trial court found that the defendant had a reasonable expectation of privacy in his office and the computer, and found that the church itself could not consent to the search because the rules of the church did not cause the defendant to lose rights under the Florida and United States constitutions. In this case, the church itself had the authority as the employer and the owner of the property to consent to the search of the office.
Are you taking issue with the first of the 2 steps, that is, whether or not the appellee had a reasonable expectation of privacy with respect to the office, given the fact that he had a key and it was his office alone? Is that part of your argument?
Essentially, the state challenges both prongs of that particular test, whether or not he had a subjective expectation of privacy, and then the second portion of the prong, which is whether or not that expectation of privacy was objectively reasonable and one that society is prepared to accept. In this case, other folks had access, particularly to that computer in that office, including the church secretary, who actually had an extra key to the church, to the pastor's office. She was also essentially acting as the IT person with respect to the internet service in this case. It was her responsibility. She was the contact person for Bell South. She was the person who could change usernames, passwords, and email addresses on their Bell South account.
So even if the office was his private office, she had access to the computer?
She did, as well as visiting officials, including other pastors, other clergy members who might have been there, who may have come in as visiting pastors or for other purposes. And the pastor's wife had accessed the office on at least one occasion by Ms. Matchett, who's the church secretary, allowing her in.
Well, does the test under Mancusi and the other cases that that no one else can ever go in the office? It seems to me the facts in Mancusi were the defendant actually shared the office with others.
In Mancusi, he shared an office with several other union officials. It appears they had some kind of desk set up in there. And the actual problem in Mancusi was not the consent to search. It was the fact that United States agents were denied access to that office and then went ahead and went into the office and seized papers from DeFord. It's actually Mr. DeFord's desk. The court there found he had at least some expectation that law enforcement agents would not come in over his supervisors and other union officials' denial and seize those papers. In this case, the pastor had no expectation that the custodian, the church secretary, and other visiting officials would not enter his office. With respect to the second portion of that, the objective standard, it's clear that in an employer-employee context, the society is not prepared to accept the rule that an employer can never enter an employee's office, that the owner of a property can never enter the
But is the flip side true? Are you arguing that as a matter of law, the employer always can consent?
In this particular type of situation that we have here, yes, because it's church-owned property, it's an office on the church property, and he is subject to the control of the church. Now, there are some cases that have held things like a locked safe. I believe Judge Posner referenced in his opinion in Muick versus Glen Eyre that things like a safe provided to an employee for safekeeping of personal articles, a desk drawer with a key that's provided to an employee as a place to keep your personal belongings, or a file drawer, file cabinet. Those things are certainly different from the case here. Here we had an office that other people could come and go from. There was another key to it, and the computer was not password protected. It wasn't locked behind a credenza door. It was exposed, and Ms. Matchett had accessed it on previous occasions to correct internet service problems.
Counsel, could others enter the office without the pastor's permission?
I believe Ms. Matchett entered as necessary, and so did the custodian. So it's hard to say whether each and every time she entered the pastor's office she would have had permission or not. It was a part of her duties to enter the office, to take care of things like internet service things, to leave things for the pastor's signature, and to allow visiting dignitaries, the church board, the trustees, as far as Ms. Matchett is concerned, anybody who was a church official, either a member of the trustees committee or the staff parish committee, were people that she would have let in the office, according to her testimony.
Did the church have a policy, as a lot of employers do, about access to the computer, and so they declare it up front that all employees should know the employers are involved in the computer and have access to the computer at all times?
This is a small church. It had some 460 members. It had three full-time paid employees, the church secretary, the custodian, and the pastor. It's not the place that has that type of policy.
Is he an employee of the church or of the Methodist Church as an entity? That was confusing to me in looking at the record.
Well, just two things. One thing I want to point out first, and then I'll answer Your Honor's question. The first thing I want to point out is that his employment and his status is something that's an ecclesiastical matter, which the United States Supreme Court has said is not for the courts or other folks to determine. It's for the church to determine. And according to the church, he was under the direct supervision of the district superintendent and the bishop in this case. The bishop, with the assistance of not only the congregation, the staff parish committee, and the superintendent, made the decision on hiring, firing, assignments, and things like that of the pastor. I believe the district superintendent had a substantial role in that, although I guess the buck kind of stopped with the bishop. The bishop in this case is actually the individual who consented to the search.
Does the church, again, have any policy in reference to others having access or use of the pastor's computer?
No, neither the church nor the pastor had written or oral, any kind of policy type doctrine with respect to the computer or the office itself. There are only two keys in this church. There's a master key that opens, well, there may be other sub-keys, but there are two main keys in the church. The master key that opens everything but the pastor's office, and the pastor's office key. So there's not a wide number of keys floating around at this church.
Counsel, are you aware of any case that holds that an employer can always give consent to search an employee's computer?
Is there any case that says that?
Yes.
In every circumstance?
That's correct.
I'm unaware of any legal authority that states that in every circumstance an employer may give consent. In a co-tenancy situation, the co-tenant can give consent to search the house, and that's really what we have here, is almost that same kind of, actually what was discussed in Georgia versus Randolph. And the difference
is a co-tenant relationship.
Well, first of all, it's the church's property. The church owns the property, and the church supervises the pastor. It is the employer. I believe there's also the Bilzanich case. It's cited in our brief.
Is ownership of the property sufficient for the employer to give consent to search an employee's computer alone?
Well, if the owner only had a tenant in a strip mall lease situation, it's completely different from this case where the church owned the premises and the church was the employer.
Counselor, below the state did not argue the ecclesiastical abstention doctrine, did it?
It was raised. It came up as a result of, as in reply to the actual answer brief of the appellee.
Right, I read it in the reply brief, but it wasn't raised in the initial brief, and it wasn't raised below. I didn't see an argument below by the state that based on the ecclesiastical abstention doctrine, the church officials had the authority to consent, and that authority can't be questioned by the judicial branch.
The state argued below that it had established that the church had the authority to consent. then...
Based on their role as the employer and the owner of the property, right?
Correct, and based on the fact that the pastor was subject to the Book of Discipline, an ecclesiastical book. I mean, obviously, the state does not get to respond to what the trial court wrote until it gets here before this court, where the trial court found that the church officials could not consent to the search because the appellee did not lose his rights under the Florida and federal constitutions. So that's essentially when this issue, specifically the ecclesiastical portion of it, came to light. The state did argue below, however, that he was subject to the discipline of the church and the church's
Do
strictures.
you think that rationale alone is adequate to reverse?
Based on the trial court's findings of fact, I think it's adequate to reverse based on the ecclesiastical abstention doctrine. I also think that on a baseline co-tenancy and or apparent authority doctrine, there was sufficient grounds to reverse.
So, counsel, would you end the discussion with the ecclesiastical abstention doctrine when the Florida and federal constitution are involved?
No, because what's happened here is the church has interpreted the ecclesiastical doctrine to preclude or to grant the appellant rights and essentially preclude the state from getting consent from the actual owner and or employer. This is also a case of apparent authority. At the very least, there's apparent authority here. The officer who actually participated in the search, Jennifer Roman, found out prior to the search, Mr. Moreland told her that he was present, that he had been told by the bishop and the district superintendent to do everything to assist law enforcement. And in fact, in this case, had Ms. Matchett simply taken that computer or any of the other parties in this case, taken that computer to the law enforcement substation, we wouldn't be here at all today. With that, I'll reserve my rest of my time for rebuttal.
Good afternoon, Your Honors. Curtis Fallgetter from Jacksonville. I have been out in private practice from the U.S. Attorney's Office for about 14 years. I may have filed a half a dozen suppression motions in my entire career in private practice, and so we don't do them lightly. We thank Your Honors for permitting us the opportunity to appear today and to elaborate on why the district court order or the trial court order was correct. And the court's familiar with its own review standards, that the trial court's order is clothed with the presumption of correctness, that the facts and inferences are to be interpreted most favorably to the sustaining the trial court's order and should defer to the trial court finder of fact. And on those facts, I disagree with what you're hearing a little bit today from the state.
Counsel, again, with regard to the trial court's presumption of correctness, how should the presumption of correctness for rulings on motions to suppress affect our review of the trial court's legal conclusions?
Well, my understanding of your decisions in McNamara in the Florida Supreme Court and Wasco is that it's clothed with the presumption of correctness both as to the legal issues, and of course there's a review standard on the facts that would have to be clearly erroneous on the facts, and they're not the least bit erroneous. They're absolutely dead on. The trial court order found that there was a reasonable expectation of privacy because it was the pastor's office and the pastor's computer provided for his exclusive use. What were the facts that supported that? Every single witness that testified said it was the pastor's office, not the church's office, the pastor's computer, not the church's computer. It had a special lock.
But the computer was provided to the pastor by the church, was it not?
Yes, and ownership, a question was asked, ownership is totally irrelevant to whether or not he has an expectation of privacy under the Supreme Court decision of Mancusi.
Yes, so, counsel, did the pastor assume the risk that his office would be searched by accepting employment at the church?
Not at all, because the church, and I quote from one of the record sites, the church wanted to make sure that nobody could get in there unless it was the pastor. They kept it locked. They had a very special key and a special lock on that door. Only 2 people had it. The pastor had 2 keys. The secretary had another key for the sole purpose of allowing him to get in when necessary. And if we create a Fourth Amendment scenario, which I hear the Attorney General saying, that the only person that has an expectation of privacy is that person that goes and buys a safe and locks it up and nobody has access to it. No janitor can come into our offices and clean without us losing expectation of privacy. The pastor went on vacation. He let some other pastors come in and use his office. They didn't use his computer, to my knowledge. But, he would do that with his permission. The secretary was in there with his permission. Mothers cleaned sons' rooms tons of case law out there that say that son retains his expectation of privacy in his room unless the mom has joint custody and control of the room, which nobody in this case had except for the pastor.
I think in my view, your more difficult position has to do with consent, because it seems to me there's a body of case law out there dealing with employers giving consent to the authorities to enter into a space that an employee may have a reasonable expectation of privacy. So address the issue here, if you would.
Well, we cite the O'Rourke and O'Connor decisions that offices and other workplaces are among the areas in which individuals may enjoy such a reasonable expectation of privacy, and we recite tons of cases. And if I might digress for a moment, I think some of the most compelling law in support of answering the court's question is the absence of law cited by the state. They've researched this. We've analyzed the cases they cited. They cite 4 cases. And if there was law out there that supported their position, presumably it would be there. They cite Muick versus Glenair, which clearly says there can be a right of privacy in an employer-owned equipment furnished to an employee. Why wasn't there? Because it was a laptop for which there was a policy. You asked a question about the policy. That's the bright line in these cases. If there's a policy that the employer says, you employee, we're going to look at your computer, we have IT departments, you have no expectation of privacy because I've told you that. And that is entirely missing here. The Balancic case that they cited involved an owner of a business. Neither Moreland nor Superintendent Neal owned the office or the computer, and most importantly, just like the bright line case law I mentioned.
Let's assume for argument purposes that there is a reasonable expectation of privacy here. Can't the employer still consent, notwithstanding that?
Not unless they have, as your court has concluded, mutual use, joint access, or control. And I cite the Purifoy case as one of many, your first district case, over the area to be searched, not the person. And it becomes a little confusing when you look at the judge's order. He was very clear on drawing the distinction between the authority of the church over Pastor Young as a pastor. And I'm citing page 3 of the order where he notes that the bishop did have authority over the defendant as a pastor. The Pope has authority over every priest in America, presumably. Does that mean they can go to the Pope, law enforcement, and ask him to sign consent to search a priest's office? I've got supervisors. When I was at the U.S. Attorney's Office, could my U.S. Attorney authorize a search of my office? And of course, the case law is that on public offices, even then, you're not entitled to. All the case law that they cite talks about cases where there's a policy in place where the employee was notified of it. The Oklahoma State case, the Ziegler case, the Angevine case, all of them had policies informing the employee at the time that they were employed that they could have access to the computers, and therefore the expectation of privacy was gone. And again, Your Honor, back to your question, who has authority to consent? It's the person who has joint access and control, not just because I'm their boss, particularly those where the individual has absolutely no use whatsoever of the facility. And the facts for both Moreland and Neal is it wasn't their office, wasn't their computer, never used the office, never used the computer, never worked there. I don't think they stepped foot in it. They never kept any property there. They had no keys there. They had no access whatsoever. And most importantly, the officers knew it. From the deposition testimony and from the suppression hearing testimony, the officers admitted that they never asked anything other than of Mr. Moreland, what do you do? Well, he's affiliated with the church. Again, how in the world would that give the law enforcement a reasonable belief that they could rely on that person's authority? They never found out if they had access to the office keys, any of the matters. So the reality is, under the facts of this case, they had no belief at all, let alone a reasonable one, because they never asked the questions that would permit them to come in good faith before the court, as Judge Davis found, and assert the proposition that they relied in good faith on someone who they thought had authority. This was a chairman, not a president. This was a chairman of the Parish Relations Committee with zero authority over Pastor Young, let alone his office space. So the officers could...
So the bishop or the bishop's representative did not grant the consent.
Here's the distinction of that. Moreland was there. He's the chairman of the parish. He signs the consent. They go in. There's a little dispute, and all due respect to Judge Davis, I have a slight disagreement with his order because he suggested that Neal consented as well. I believe the correct transcript says that he wanted to cooperate, which is what we heard the Attorney General say just a few moments ago. But the two important facts on that, Neil, the superintendent, who was a theological supervisor of Pastor Young, had a conversation with the officers once they're inside. They were already inside, and of course, since they were already inside, it was too late for the consent to be valid because they'd already breached the Fourth Amendment. And the second thing,
Counsel, though, assuming Neil did consult with the bishop in this case, does the bishop have the authority to consent to search of the computer?
that's the red herring in this entire case. As I go back to my example of the Pope, all due respect to the Pope. He didn't have authority over priests to consent to the search of their offices. Federal judges have supervisors, state judges do.
What if the Pope said he did have that authority to consent to a search of the priest's office?
Well, they didn't say that here, and they knew.
I'm asking as a hypothetical. What if the Pope said, I have the general authority to consent to a search of any priest's office in the world?
And the law enforcement officer asked no question and just accepted that. I would say that was not.
The Pope just issued that statement and said, I have the authority to consent to any search of any priest's room, residence, office, home, anywhere in the United States. And I hereby give that consent.
And if that happened and the law enforcement officers relied on it, I would hope the trial courts and the appellate courts would look at that and say that could not possibly be reasonable reliance, because for there to be authority to consent, the officers know the law. You've got to have the joint access and use, not just a supervisor. They can't walk in and ask some supervisor or the Pope or anybody else and artificially get consent, which is exactly what they did here. They chased the pastor off, armed guard, sent him away so he could not be present.
But under the abstention doctrine, hasn't the court said that under the First Amendment, in that hypothetical, the head of the religious organization can give that consent? Once the head of the religious organization, depending on his religious authority, makes that decision, the matter's closed, right?
No, sir, not the least.
That's not the abstention doctrine in your view?
Not as I understand it, because the extension doctrine deals with theological authority, not Fourth Amendment, and certainly doesn't contravene this court's own decisions that the only persons who have authority to consent to a search are those that have joint access and use. And the law enforcement officer that artificially goes to someone that they know has no such authority, Pope's in Rome, he's going to authorize a search in Jacksonville. I would hope your honors would find that to not be objectively reasonable either. But it didn't happen here. They didn't ask any of those questions. And they never talked to the bishop. They entered the office with the consent of Moreland, who signs a consent form that's in the record, and I've brought copies, that says he's consenting to a search of my computer. Absolutely not. They knew it wasn't Moreland's computer. And I asked the court to also give some thought to the issue of the removal of Pastor Young. Shows up at his office to go to work. An armed Jacksonville sheriff's officer tells him to leave. Your decision in Pugh versus State, citing the Florida Supreme Court in Silva, says a third party may not validly consent to a search where the person against whom the search is directed is present and objects thereto. Pastor Young wasn't present because he was removed. I would respectfully suggest that your decision foretold the U.S. Supreme Court decision some 9 years later in Georgia versus Randolph, which held the police may not remove the potentially objecting party for the sake of avoiding a possible objection to the search. And who did they get the consent from? Moreland, who was a representative of the church, whatever that means, and the complainant. So folks with Fourth Amendment privileges lose their ability to object because they're hurried off by armed police officers, and the police don't get consent from a person that they knew nothing about, and by that mere titles alone, they knew he didn't have authority to consent.
Counsel, address the fruit of the poisonous tree argument. It seems to me that here the police had not searched the computer, had not seen the video at the time they questioned the defendant, and in fact they had knowledge of the general nature of the material from sources other than the search. Why should we affirm that part of the trial court's order?
Frankly, I don't know if it's relevant to any of us. There were no substantive admissions made about the video. The officers talked about contents of the computer, so we think it's clearly not a break in the chain of illegality, but I'm not so sure that any of it's relevant.
Do the officers have the contents of the computer in their possession at the time they questioned the appellate?
They did, and they showed him extracts from it. They discussed it with him, so he knew they'd been in a computer. He didn't know what they'd seen or not seen, but quite frankly, Your Honors, the state wouldn't proceed with the case because he absolutely denied, the existence of any child pornography. So I don't know that it's relevant. I believe the only reason it's been asserted by the state is because they want to make a bootstrap argument that statements that he made in having a sort of legal discussion with Detective Boimer at the time about, do you have an expectation of privacy? And Boimer's talking about his laptop and how he doesn't have any in his, so, you probably don't have any in yours, do you? And the pastor says, well, I hadn't really thought about it. Of course, that was a misstatement of the law. The laptop is portable. You move it. The sheriff's office has a policy against, that they can look at it at all times. So he was misadvised on the law, but I think the state wants to do it to use the statements tainted by the illegal search to attempt to justify the illegal search itself by...
Also, again, in regards to the fruit of the poisonous tree argument, let's assume that the detective gave the appellee proper Miranda warnings and the appellee voluntarily talked with him. Why would that course of events not be sufficient to remove the taint of the illegal search?
The interrogation was about 2 hours after the search. They told him about the search. They caught him as he's leaving the superintendent's office where he'd just been suspended. So he's in a bit of a state of shock. The police had gone to his house and interrogated his wife. He knew all that. And then they show him the fruits of the search, the contents of the computer. And I don't think the fruit of the poisonous tree law...
Did they show him anything other than a printout of what had been bookmarked? Or did they actually show him the computer?
Didn't show him the video, didn't show him the computer because it was back in their custody, but they showed him some contents of it. And I don't think the fruit of the poisonous tree law requires that they reveal to him the precise nature of the illegal substance. In other words, if there's something illegal on the computer and they're trying to get statements from him about it, in this case, statements of lack of expectation of privacy, all of that is driven by his knowledge that it's the cat out of the bag. They got my computer. Why am I going to quibble with them about whether I have an expectation of privacy? To him, it was all moot, which is really, Judge, it's the only reason that they want that in anyway. There's no incriminating statements made. They would seek it solely for the bootstrap purpose of trying to put in the sort of ambiguous comments about, well, laptops with sheriff's office, maybe I haven't really thought about it. Maybe I don't have an expectation of privacy. So,
but didn't he admit to viewing what I think is referred to as teen sites?
Teen sites with absolutely nothing about child pornography, and he thought the teen sites were adults. So, I mean, the state attorney in my dealings with him before, that this is, I would certainly think that the opinion ought to be affirmed, but and to me it's somewhat of a tempest in a teapot because my understanding of those statements, they would only want them in for the consent issues, but certainly it is, to answer Judge Lewis's questions, it follows so closely, and the law requires clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the taint of prior official legal action, your first district case in TLW, and the burdens on the state. So respectfully.
Just a follow-up question, counsel. I know your time is about out.
Yes, sir.
How would the appellee have answered the law enforcement detective's questions differently if he had not known about the search?
He testified at suppression hearing he would have denied consent, would have at a minimum asked for a lawyer. And of course, that's what the answer would have been. And of course, reading the transcript, as I say, the way they even got him to go down that slippery slope was to give a bogus example of a actual sheriff's office laptop not having expectation. The officer testified, yes, the man relied on me. He knew I'd been a detective for 20, 25 years. He presumed I would know the law of search and seizure far better than he. So, yes, when I'm telling him that there's no expectation of privacy, I would expect a pastor to agree with me, and he tried to in a very ambiguous way. So the answer would have been no if he had been properly informed and wasn't aware that the illegal search had already taken place. So he testified at the suppression hearing.
Thank you, counsel. Your time has expired. Sure. Counsel, I'll give you 5 minutes total.
Thank you, Your Honor.
Satisfactory.
That's
if we've got
fine.
questions, we can feel free to run beyond that.
Absolutely. The first thing I wanted to point out was, with respect to this, he was chased off. First of all, the trial court made a specific factual finding that the church officials had instructed him to go home and stay there. It appears that law enforcement officer,
He came back, right?
It appears that at some point in time he came back and he's outside with Officer Lamb, who's just the patrolman. He's not the detective. He doesn't do the search or anything like that. Is outside with Mr. Moreland, the chairperson of the Staff Affairs Committee.
He's in uniform?
I assume so. I think that's the testimony in the record. He's outside with Mr. Moreland, and Mr. Moreland tells him that Reverend Niels told him to go home. And at some point in time, apparently, the law enforcement officer said after, there's a whole a bit in the transcript about it, and I believe I've actually block quoted it in our brief. It appears that he just simply said, look, the church has said they don't want you to be here, go on home, and that's what happened. But I want to point out that that's not dispositive of anything, because in Georgia versus Randolph, the United States Supreme Court said it had 2 loose ends as a result of its decision in that case. Its second loose end was what to do about the significance of Matlock in Illinois versus Rodriguez. And the court stated, although the Matlock defendant was not present with the opportunity to object, he was in a squad car not far away from where the search occurred, and they obtained consent from another party. And the Rodriguez defendant was actually asleep in the very same apartment where they were conducting the search, and police might have roused him with a knock on the door before they entered with only consent of the apparent co-tenant. If those cases are not to be undercut by today's holding, we have to admit that we are drawing a fine line. If a potential defendant with self-interest in objecting is in fact at the door and objects, the co-tenant's permission does not suffice for a reasonable search, whereas the potential objector nearby but not invited to take part in the threshold colloquy loses out. The Supreme Court's already ruled on that matter. And that is that the fact that he had been absented, whether you believe he was absented by the church itself, who had instructed him not to be there, the appellee latched on to some words from the hearing that were of the nature of Reverend Niels suggested he not go to the church that day and told him not to turn on the computer. Apparently that suggestion was more of a mandatory rather than a permissive suggestion based on the trial court's findings as a result of hearing that testimony in the hearing.
Aside from consent, Counselor, going back to an objective expectation of privacy in this case, which you contend does not exist, essentially, in this, doesn't it seem reasonable to find that there is such a reasonable expectation of privacy here when you have a small operation church, as you say, there's no network among computers, there's no IT policy, there's no authority for anybody else to use that computer. The only key is in his secretary's possession for emergencies or situations where she may have to let somebody in. I know aside from consent, you could still prevail on that argument. But outside of that context, does it not seem to you that a person, an employee, outside of the religious organization context too, an employee in a small office with a computer purchased for that employee, with no policy allowing the employer to access the computer, to overlook the shoulder, et cetera, isn't there a reasonable expectation of privacy in that employee's workspace?
Several of the factors that you just suggested, Judge Thomas, mitigate against that expectation. He's in a small office. He expects certain people to come and go from that office, including the custodian, Miss Matchett. And in this case, Miss Matchett is really the equivalent of the IT guys where there's a firewall in place, because your IT guys are the ones who are monitoring the internet usage and stuff like that in their own area. Here in this case, they're not networked, so there's no firewall to monitor. So Miss Matchett goes from time to time and runs Spybot on her computer, fixes internet problems on his computer, runs Spybot on his computer.
But it's very different, is it not? Excuse me for interrupting, but it's very different, is it not, from a large corporation or a large organizational setting where, A, employees are told your computer is not private property, it is not your domain, you are prohibited from certain activities. On public computers, many things on that computer are public record. Here, is it not reasonable to find there's a reasonable objective expectation of privacy?
No, precisely in a small office, what you would expect to find is less rules, less formalizations, less all of the things that are present in this case. In a large corporation, you expect there to be structured rules, structured ways of dealing with things because of the sheer number of employees. Any employee who happens to have a locked door there is probably the only person with a key. Maybe the janitor has one just in case he gets locked out. But because of the informalities of the structure here, he had no reasonable expectation, objectively reasonable expectation, to think that no one would go into his office, no one would look at his computer, that when he left there they wouldn't search that computer, that they wouldn't take that computer out of his office for repairs as they had previously. It's a less formalized structure, so there are a lot less of those formal strictures in place. And so, I harken back to when I was in private practice with my father. It would have been ironic for him not to have been in my office or in and out of my office, even if I locked it when I left at the end of the day. It wouldn't have surprised me for anyone to go in and out.
Let's assume, for the sake of argument, that the appellee had a reasonable expectation of privacy in his computer. Then what is the break in the chain of illegality between the search and the interview by the detectives?
All the detectives knew is that they had, when they left for the search, all they knew is they had searched the office and they had taken the computer and 2 Post-it notes that had been abandoned in the trash can or next to the trash can. The record seems to indicate one was in the trash and one was outside the trash. That's all they knew when they left the office, was they had a computer and they had some sticky notes. That's all they had from the search.
What about the printout of?
They had been told by the church that the IT professional had obtained some kind of CD-ROM, which apparently was printed out, that indicated that he had visited certain sites. That was something the church did itself with its own hiring of an IT person. It had nothing to do with law enforcement. And in fact, had been accomplished prior to the day the church called law enforcement, and had been accomplished prior to Reverend Neal discussing it with the bishop over dinner, whether or not to give consent and get law enforcement involved. So when he goes there, they don't have anything to be a fruit of a poisonous tree. They don't have the child pornography. All they have is stuff that they could have had anyway. They could have gone to Reverend Neal's office and interviewed him, whether the search had been conducted or not. And they interviewed him, and during that time he made some statements. Now, whether or not they're admissible is certainly something for the trial court to determine. But he also did say, I never really thought about whether I had an expectation of privacy in there. Well, if he was so certain that his office was private, the answer to that question should have been, my office is different than your computer. I mean, no, you shouldn't have been in there. I expected that no one would ever access my computer. And that's not what happened in this case. And with that, the state asks you to reverse the judgment of the trial court.
We will stand in recess for a few minutes and